3, 2, 1, start. The Labour Court answered both the questions in affirmative and made an award that the increased emoluments to the second category of workmen will become payable from 1/10/1983. The correctness of the said award was challenged in a writ petition filed by the appellants. The learned single judge of the High Court, while deciding the writ petition, held that the settlement dated 3/9/97, which became effective from 1/10/1978, having been acted upon and during the subsistence of the settlement, the reference could not have been made, and moreover, the parity claimed in the emoluments to be paid to the workmen and the ministerial staff forming separate categories cannot be drawn, and therefore enhancing the remuneration from 1/10/1983 is untenable, and allowed the writ petition by setting aside the award made by the Labour Court and rejecting the reference made by the government. On an appeal, the division bench of the High Court reversed the decision of the learned single judge and restored the award made by the Labour Court. Hence, this appeal, the view of the learned single judge, is commanded for acceptance by the learned counsel for the appellants. Undoubtedly, the legal position is that during the subsistence of a settlement, it is not open to any of the parties to raise a dispute. A settlement once entered into between the parties shall be operative until the same is terminated, as provided in Section 19 of the Industrial Disputes Act 1947. The object of such a provision is to ensure that once a settlement is entered into, then industrial peace prevails between the parties during the period agreed upon. The same position should continue by extension of the settlement by operation of law. There is an option given to either party to terminate the settlement, and such a course having not been adopted in the present case, the dispute could not have been raised by the parties. But in an appropriate case, the government may make a reference under the Act on the ground that since the settlement was entered into, there has been material change in the circumstances. In the present case, the Labour Court noticed such a situation arising as a result of the second settlement entered into the workmen, that is the third category of employees. In the original settlement between the parties, there has been no provision of working in the mills all 7 days in a week, nor was any provision made in regard to higher emolument applicable to either class of workmen. The Labour Court noticed that a gardener who had been categorized as a member of the staff coming under category 2 could get less emoluments than his helper who comes under category 3, and therefore in those special circumstances, in view of the change in the working conditions, the Labour Court gave relief to the employees coming under second category, but from a date on the expiry of the agreed settlement entered into by the parties. Section 19 of the Act limits the variation of settlement, but if there has been any material change in the circumstances available in the establishment of an employer, certainly such a situation cannot be ignored. Stop.